Hello.
Hi, Rishabh.
Hi, Vishwan. How are you? Are
I'm
you
fine,
judging
thank you.
me?
How are you?
But are you judging
So,
this with, or I mean, I thought it was someone else.
yeah, no, it's Mr. El Saeed. Uh, I've just contacted him to see if he's joining. Just so you know, University of Reading just backed out this morning, so we're basically going to proceed ex parte.
Wow, that's interesting.
So, but I think you can start you can obviously take the lead and start the round.
No, we'll
Uh,
wait for the other guy, the other judge, and we'll wait for 5 minutes.
okay,
Yeah, sure.
thank you.
Good afternoon. This is Nabiha Khan, the senior respondent. We'd just like to clarify that
Yes, miss.
since University of Reading has dropped out, what does that mean for us? Do we still continue with our submissions, or how's it going to go forward?
You are for the respondent, right?
Yes.
Proceed on the basis that they have made out a case, uh, and you will respond to it because we score you on the basis of time of your oral arguments.
Okay. So do I begin?
We need to wait for my other judge, so give us a minute.
Okay. All right. Thank you so much.
Good afternoon, everyone. This is Delvin speaking. Rishabh, if you can hear me, if the team members have all joined the session, please proceed. You can start the session. Rishabh, I will just confirm first that the judge is hearing all of us. Rishabh Jugani, can you hear me? Rishabh, can you hear me?
Hi, Rishabh. Can you hear me? Hi, Rishabh.
I think the judge texted in the chat saying, "Give me 5 minutes."
Sure, sure.
Hi, sorry. I am so sorry.
No, not at all. You can start the session, I think, Rishabh.
Okay, cool. So I take it that the other judge is also not joining.
Yeah, I'm not sure if he.
Are you going to judge then, Vishwan?
I'll come back to you, Rishabh.
Hi,
If
Delvin. So I think Delvin was trying to contact me. Was it Delvin?
Yeah, I think Delvin was trying. I'll tell her that she basically just asked me to ask you to start the session.
Cool. Anyway, let's start then. Sorry, Miss Khan, and I think there are two Khans, three Khans. Sorry.
Yeah, there are two.
I can see a Zaina Khan as well. But anyway, Miss Nabia, I'm all yours. Sorry, I have terrible background, but anyways, I can hear you. Am I audible?
Okay. Yes, you are.
Perfect. Do you want to begin? Let me know when you're ready.
Yeah, we're ready. I'll begin now.
Yeah, sure.
Good afternoon. May it please the court. My name is Ms. Nabiha Khan, Senior Counsel for the Respondent, Ms. Raz Rani, along with Mr. Mohammed Khan, the Junior Counsel for the Respondent. We would like to allocate 15 minutes each for our submissions, and I will be addressing the first ground of appeal. For the benefit of your honor, I shall reiterate the facts of the case relevant to my submission. On June 10th, 2022,
Ms. Khan, I think I'm aware of the facts, so I don't want to be. Let's move to the basis that you say that the order of the court of first instance must be upheld.
Yeah, okay. Your Honor, with the facts, which I don't need to state anymore, I have three submissions to make negating the first ground of appeal challenging jurisdiction. First, the appellant did not provide any evidence or a good arguable case that the IFC court's jurisdiction fails to apply in our current case. Second, the contract was partly performed in the DIFC, allowing DIFC courts to govern the disputed trade. And third, the location of the node determines that DIFC jurisdiction applies to this trade. With regards to my first submission, that is, the appellant needing to provide evidence and a good argument, I would like to cite the DIFC Court Rules Part 12.10 found on page number 31 of our court bundle, which states, if a defendant makes an application under this part, he must file and serve his written evidence in support with the application notice. According to the facts of our current case, the appellant did not provide any written evidence supporting his application. Furthermore, I would like to mention the case of Tulip Trading Limited versus Bitcoin Association for BSV, reported in the Chancery Division of the England and Wales High Court in the year 2022, starting on page 667, which will be found on page 274 of our court bundle. For the benefit of...
Can you give me some details?
Yes. The facts of this case revolve around the claimant who allegedly owned $4.5 billion of Bitcoin on... I will repeat myself. The facts of the case revolve around the claimant who allegedly owned $4.5 billion of Bitcoin on the defendant's networks. And in the same year, the CEO's computer was hacked and the private keys had been erased. However, the defense argument stated that because none of the defendants were in the jurisdiction, the appeal should be quashed. In this instance, the court held that the claimant has to satisfy that there was a good arguable case that the claim fell within one or more of the jurisdictional gateways. I would also like to support this with another case, Howard Norman Leedham versus Oxford Investment Managers Limited, case number 6 of the year 2008 in the DIFC Court of First Instance, which was held on the 22nd June 2010, which will be found on page number 195 of our court bundle. The facts of the case are not applicable to our current case. However, my argument arises from the court specifically stating that if the DIFC court's jurisdiction is challenged, the claimant must satisfy that DIFC court has jurisdiction according to Article 5 of the DIFC Judicial Authority Law, which I will mention later on. Your Honor, bearing these authorities in mind, it is my submission that according to these facts of our current case, the appellant, Mr. Payne, did not provide any written evidence or any good arguable case supporting his application challenging the court's jurisdiction. My second submission will be divided into two parts. The first is that the transaction between Mr. Payne and Mr. Rani qualifies as a contract, and the second, that this contract was partly performed in the DIFC. With regards to the first part, I would like to mention Carlisle v. Carbolic Smoke Ball Company, published in the first volume of the Queen's Bench of the year 1893, starting on page number 256 of our court bundle.
No, but I mean, Carlisle is an authority for something else, right?
Yes, but I would like to use this just to prove the fact that the transaction of $250,000 in exchange for 100 Yapple can be held as a contract, similarly the way the transaction of the product and the money between the defendants and the plaintiffs in Carlisle v. Carbolic was qualified as a contract.
Okay, can you give me the facts of Carlisle?
Yeah. So the facts of Carlisle v. Carbolic are about the plaintiff, Ms. Carlisle.
I'm listening.
Yeah, sorry. So the facts of this case were about Ms. Carlisle purchasing the smoke ball from the advertisement by the company because they advertised that this was going to cure influenza. However, because this did not cure her influenza and the advertisement specifically mentioned a £100 reward for anyone who does not benefit from this product, she issued proceedings in the courts and claimed for reimbursement. And the court held that this was not an invitation to treat. However, it was a unilateral contract, and therefore the company should be binding over their clause in the contract, which they portrayed as an advertisement, and should pay them £100. So I would just like to use the fact that this transaction between them was counted as a contract into our current case, that the transaction of $250,000 debited from Ms. Rani's account in exchange for 100 Yapple qualifies as a contract. May I proceed with my second part of the question?
Okay. So you're saying that this does qualify as a contract?
Yes.
Even though, I mean, I don't see how Carlisle is authority for the point, but you know, what about the fact that this was a contract which is sort of, you know, with the technologies of sorts, it was all automatic. And given that the technology admittedly was flawed, or there was some sort of an error in it, it's possible that one can say that the contract should be avoided.
I understand. However, I'm trying to argue that at the end of the day, what happened between the two programs of the parties was that one party had debited some amount of money in exchange for some amount of currency, which is crypto, which can be used as a product in this scenario, and that transaction of someone's account being debited for some sort of money in exchange for some specific amounts of product will qualify as a transaction, which in turn qualifies as a contract, like in the case of Carlisle, the product, the ball, the medicine curing influenza, in exchange for the money that the claimant.
No, I understand what you're saying, but you know, there is a fundamental flaw here that at the end of the day, what you are trying to say is, you know, the elements of a contract, and one of them would be compensation, which is what you're using Carlisle for. But here the argument is one of mistake, saying that, you know, there was a glitch per se, and the consideration was a consideration that should have not passed, because had it not been for the error, this transaction may not have happened at this price.
I agree. However, in order to prove that this transaction, the DIFC courts do have jurisdiction over this transaction, I would begin with proving that this transaction qualifies as a contract. And in order to prove that, my only substantial tests that I need to check were that there was money debited from my client, Ms. Rani's account in exchange for something else. even if there was not an error due to which the trade happened at a very inflated price, the basis, the fundamental of this transaction was still money being debited in exchange for a product which qualifies it as a contractual transaction.
Okay, sorry. Maybe I'm being slow on this. So you're telling me that the DIFC court has jurisdiction,
Yes,
correct? And
yes,
the fact that confers it jurisdiction is the fact that a transaction took place where money was charged. Am I correct?
yes,
But that is exactly what a contract is.
yes,
There is consideration passed.
yes.
So, I mean, how does it confer jurisdiction on the DIFC court is our concern, because which part of the contract was performed in the DIFC or was to be performed in the DIFC, you sort of need to establish that first. Uh,
Yes, that
we take
was
your point that a contract exists. Whether or not the contract is validly formed is a secondary question, but you need to establish firstly as to why we must even hear you in the first, at first instance. Satisfy us
yeah.
on jurisdiction.
Yes, so this was going to be the second part of my submission, that after once I prove that this transaction was a contract, then I would move on to proving how this contract, how the IFC courts governed this contract.
Okay.
Okay, so may I proceed with my second submission?
Sure.
Thank you. So I would, to proceed to the second part of my submission, I would like to reapply the case of Al-Khafari versus Bank Sarsen, the third case of the year 2011 held in the DIFC Court of Appeal on 5th January 2012. This can be found on page number 258 of our court bundle. This case was used in the court of first instance to judge in favor of Ms. Rani. However, Your Honor, I'd like to bring to the court's attention a different application of this case, which is that the DIFC courts judged this case as one of the parties was living in Dubai. And since DIFC jurisdiction is an opt-in jurisdiction, it satisfies Article 5A1 subsection B and C of Law number 16 of 2011, which can be found on page number 274 of the court bundle. Article 5A1 subsection B states that civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partly or wholly concluded, finalized, or performed within the DIFC. And subsection C states that civil or commercial claims and actions arising out of or relating to any incident or transaction which has been wholly or partly performed within DIFC and is related to DIFC activities. Now, when we apply this to Ms. Rani's situation, as mentioned before, the DIFC jurisdiction is an opt-in jurisdiction, which implies that Ms. Rani, regardless of not living in the DIFC, still can issue proceedings in the DIFC courts, and therefore makes her partly performing the contract from within the DIFC. And therefore, my argument is that Ms. Rani took part in this contract, partly in the DIFC, hence satisfying Article 5A1 subsection B and C. Now, my final argument.
Sorry. Let me. In an opt-in contract, for a contract to exist and for you to confer jurisdiction, what you really need to do is both parties need to confer jurisdiction. You can't unilaterally confer. What about that? Because you have an appellant objecting to jurisdiction. So Ms. Rani may well, reside in Dubai and apply to the DIFC court. That doesn't really confer jurisdiction on us, because where is the defendant based is something that we might have to consider. Is the defendant subject to our orders?
Thank you so much. So over here, I would like to argue that after proving that Ms. Rani partly performed this contract from within the DIFC, the jurisdictional gateways of the DIFC courts broaden and open because the judicial authority law, which states out the requirements of DIFC courts having jurisdiction over a civil or a commercial claim, and the articles 5A subsection B and C that I mentioned state how the contract or the transaction can be wholly or partly performed within the DIFC. And because Ms. Rani satisfied the partly performed within the DIFC clause, I argue that this completes the requirements of the
No,
digital.
so that's my point. Ms. Rani lives in Dubai, not within the DIFC. DIFC is an offshore jurisdiction.
Yes.
How does she partly satisfy this requirement is what you're unable to explain. You need to satisfy me on that point.
Okay. So she lives in Dubai. However, she decided to issue proceedings in the DIFC court, and which is a legal.
A party may choose to, issue proceedings in any court. That
Yeah.
doesn't confer jurisdiction on that court. That's not how the concept of jurisdiction works. You need to explain to us how this court would have jurisdiction by the fact that the contract was partly or fully to be performed within jurisdiction. We see nothing on record or nothing in your arguments to hold that.
I would like to support this by my final argument about the location of the node. So in the end, I would conclude by stating all of these reasons, which substantially support the argument that jurisdiction does apply. So if I get the chance to complete my third argument.
So Ms. Khan, just a bit of advice on this. That should have been your first argument. That this is what the test is, that there must be something within the jurisdiction, and the thing that is in jurisdiction is the node, and therefore you have jurisdiction, and the node is enough to confer jurisdiction because of XYZ. The way you've approached it is the other way around, and that's not helping because you've already lost I'd say my attention on this point.
I apologize for that.
No, you don't need to apologize. It's just you need. So you're saying that the node being within the DIFC is good enough for the DIFC to have jurisdiction. Am I correct?
Yes, that would be my next argument.
Okay. Now the fact that this node is one in a few hundred, does that not really mean that 100 courts would assume jurisdiction if your argument were to be accepted? Because wherever the other nodes are, those courts would automatically also have jurisdiction. So
that is correct. But when I talk about the location of the node being a vital aspect in determining the jurisdiction of the crypto transactions, I would like to state two authorities, one being a landmark case and one being an article from a very one of the leading law firms of the world. So may I proceed with these authorities?
Well, I'd like to know that the case that you speak of, I don't need an article of a law firm because it doesn't need to be biased. But sure.
Yeah. All right. So the case I would like to mention is the Tezos security litigations held in the 148th District of the United States District Court for the Northern District of California, with the case number 317 CV06.
Okay. What does the court hold and why?
So would you like me to summarize the facts of the case, or do I go into the... Okay. So basically, the fundamental allegation in this case was that for 2 weeks in the July of 2017, the defendants unlawfully conducted an initial coin offering, also called ICOs, for tokens called Tezos. And during this period, the investors contributed digital currencies, including Bitcoin and Ethereum. And the plaintiffs specifically dealt with Ethereum. So the California District Court in this case decided that they had jurisdiction over these transactions by analyzing multiple factors, and one of the most significant one being the presence of Ethereum nodes in the United States. The court held that due to the nodes being populated in the United States, there's a higher possibility that the information of these transactions were held in these nodes, and therefore that supports the conclusion that the purchases occurred in the United States. Now, crypto being a very novel part of law, it lacks a lot of...
How many nodes were there in total in this case? The case that you
in,
said?
in the Tezos. So in this case, the court argued that due to 30 to 40 nodes being populated all over the United States,
30
they
to
use
40.
that as an argument. Yes.
Okay, out of?
Out of all the nodes in the world
Which
of
is how many?
Ethereum,
Which is how many?
which I would estimate to be
I'm sorry?
around 100,000.
So you're saying that the 30 to 40 nodes out of a few thousand would confer jurisdiction. That's the standard that the court found.
Yes.
What about this case? You have one node. Is that enough?
I would like to use that as an argument that yes, the one node being present here and the Mr. Payne not providing any argument and or any evidence in support of his challenge against the DIFC having jurisdiction would confer that the DIFC courts should apply here because
Mr. Payne does make an argument. I mean, that's why we didn't appeal.
but according to the facts of our case, he submitted an application challenging the jurisdiction. However, he did not provide any written evidence as the DIFC court rules part 12.10 asks the claimant to do.
Okay. Fair enough. Proceed.
So with all of these arguments stated, I would like to summarize my submissions by once again mentioning that Mr. Payne did not provide any written evidence or any good arguable case supporting why DIFC jurisdictions should not apply, and the case of Tezos securities litigation using.
I think I'm satisfied on this point. Let's hear your co-speaker.
Thank you so much.
Just give me a second. Hi. Okay, so I will begin. May it please the court, as introduced by my learned senior, Ms. Nabiha Khan. My name is Mr. Momin Khan, junior counsel for the respondent, Ms. Razrani. I will be addressing the second round of appeal. For the benefit of the court, I shall reiterate the facts of the case relevant to my submission, if allowed to do so.
I don't think I need the facts, but thank you.
Okay. Then in that case, my first submission is based on the case of Statoil ASA and Louis Dreyfus Energy Services.
What is the point that you wish to make, counsel? Could you establish that first?
Just give me a moment. So I will not be disputing or arguing against the Court of First Instance's decision to apply Lord Mance's reasoning. Instead, my submissions will contend with the circumstances surrounding the mistake and why my client believes that there is a valid claim for the avoidance of the contract. My first submission will be arguing that just give me a moment, I'm sorry. My first submission will be that the price of a contract is its most important fundamental term.
Sorry, could you repeat yourself? I don't think I heard any of that properly. Your first submission will be
that the price is the most fundamental term of the contract. And this will lead into the next submission that I make regarding unilateral mistake at common law and then unilateral mistake at equity.
Sorry, you say that the price is an essential element.
Yes, the price is according to Statoil ASA.
We understand that's the basis of the contract to exist. So I don't think we need to hear anything on that.
So would you like me to
skip help us understand why should we hold that this court has, should interfere?
Yes, I'm contending with the submission of unilateral mistake made by Mr. Payne, by I think Mr. Razani, and I will be arguing 3 different jurisdictions: the English court, then its long-standing authority on unilateral mistake at common law, the Singaporean court's equitable doctrine of unilateral mistake at equity, which was mentioned in the case of Coin and B2C2 Limited. which is a case that was mentioned by the court of first instance, and then finally the application of the circumstances to the DIFC's law on relevant mistake.
I think we'd like to hear about the DIFC first, given that might be binding precedent.
That's my final argument, but I will get to that one. So I would like to cite Article 37(1)(a) of the DIFC contract law. It states that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and if the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. In applying the contract law of the DIFC to our case, it can be concluded based on the findings in the court of first instance, and here in my submissions, the mistake does fall under the criteria mentioned, namely that the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and the other party knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. A trade concluded at an inflated price of 250 times the prevailing market price could hardly be regarded as a situation that is beneficial to both parties. Furthermore, if Ms. Rani had not immediately become aware of the mistake and Mr. Payne had taken his unjust enrichment without bringing the mistake to her attention, it would undoubtedly have fallen within the scope of Article 37's reasonable commercial standards of fair dealing section. As Mr. Payne's actions have clearly indicated at this point, he does wish to keep the contract as it is. Allowing the contract to remain as it is and not avoiding it would, based on the findings here, completely contravene the aforementioned text of Article 37(1)(a) of the DIFC contract law. That is my submission regarding the DIFC relevant mistake.
Okay, proceed. Sorry.
Would you like me to discuss the English court's view on this or the Singaporean court's view, seeing as the Singaporean court's view was also in?
Well, I understand the fact that it is your position that this contract could be avoided by the fact that there was a mistake. Am I correct?
Yes.
And you say that the mistake is really the fact that, had it not been for the server glitch, you would have not entered into this transaction.
From what I've understood, it's basically that the server glitch occurring was something that happened, but then acting based on Singapore court's approach and the English court's approach, acting on a mistake and insisting on the contract when the mistake is to a fundamental term does make it a mistake in equity and in common law, according to other jurisdictions. And in the DIFC, it mentions specifically that the mistake must have been known to both the parties, and if you leave the mistaken party in error, then it's contrary to reasonable commercial standards of fair dealing. So what I'm concluding here is that Mr. Payne became aware of the mistake at the same time as Ms. Adani. And once he was aware of that mistake, it was then unjustifiable for him to insist upon it to keep the money he gained from the transaction.
Okay. But, I mean, don't you think a remedy would have actually been to initiate proceedings against the platform? Because that's really where the mistake occurred. I mean, Mr. Payne does...
That is a point that me and my team had considered. However, in the moot problem itself, it mentions that there is no question as to levity's liability to both the parties.
Okay, great. I think that's it from me. Considering there is no co-judge nor respondent, this has been a very interesting round. All right. I think both.
Just out of curiosity, can I ask something?
Sorry, you're barely audible. I'm sorry. Could you repeat yourself?
Out of curiosity, can I ask something pertaining to when judges question the respondent or the appellant?
Yeah, of course. Go ahead.
When a judge questions the senior respondent or appellant, is it permissible for the counsel to then say, maybe have a moment to deliberate with the junior and the senior?
I mean, it really depends. Some people are okay with it, some are not. In the previous round I judged, we were okay with it, but it may not be always appropriate as well. It's, if it's a question which is completely out of the blue, we understand. But if it's on something that you've you are arguing and you're referring to yourself, and if you're unable to answer,
Right.
that's not great.
Yeah.
So it's,
Yeah, exactly.
I mean, it's quite a lawyer answer at the end of the day. The,
I mean, that's
okay, the only
that's a
thing that
given.
I'd say, Mr. Khan, is your audio is, I'm not holding it against you, but your audio is a little laggy. So there is a little bit of difficulty for at least myself to hear you too well. Maybe if you can, slow down your pace, that'll help to cover up the lag. I'm not holding it against you there. I mean, we're all using, a virtual mode, so there is a bit of technology that doesn't help all of us,
Right.
but it is what it is. Okay, this has been good. I can't say both teams have done a great job, but you guys have done a good job.
Thank you.
So, good stuff. I will send over this course to the IFC or the organizers, and good luck for the next round.
All right.
Thank you so much.
Have a good day.
Thank you. Thank you.